You've got 4 serious felony offenses here that have been alleged. Criminal actions have consequences. That is all. You were in custody, sir. 25 CR 307 is called the State of Texas versus Mitchell Joseph Sylvester. Is that you?
Yes, sir.
Notice how the judge wastes zero time, straight to business. No small talk, no pleasantries. When you're staring at multiple felonies, the courtroom turns into the coldest room in the building.
Aggravated robbery, which carries with it up to life imprisonment if convicted. But it doesn't end there. I'm looking at 4 prior felony convictions beginning in 1980, aggravated.
4 priors stretching back 45 years? That's not a record, that's a criminal career. The judge isn't just reading charges here. He's building a timeline that makes the defendant look like he's on a decades-long greatest hits album of felonies.
Thereafter, that became final. You committed the felony of another illegal possession of a controlled substance and was committed in 1991. You were convicted next door in the 252nd. After that became final, you committed the felony of having a prohibited substance in a correctional facility, a 3rd-degree felony, and you were finally convicted of that in 1996 in the 252nd District Court. So if you were found guilty and all of this were proven true, you are looking at no less than 25 years in prison, up to life in prison. And since a deadly weapon was used, of course, you would not be parolable for whatever sentence up to life until you served at least 50% or half. Do you understand how serious this is? Do you understand how serious this is, sir? You went through the system 4 separate times in felonies, and you were back with a violent crime? That's a rhetorical question. I don't expect an answer. All right. What do you want to do today, Mr. Manaldi, as his lawyer? Does he have an indigent form? I guess he's indigent. I don't know. But does he have an indigent form?
We are going to work on it after I'm done with my appearance because he doesn't have his glasses. So I'm going to hold him.
There was something done here where 4 things were filled out, just 4 spaces out of this multi-page document, and then it was approved by a magistrate. You just can't make this stuff up.
And here's the comedy hidden in tragedy: paperwork. The indigent form, basically a financial affidavit, is supposed to be airtight. Instead, it's 90% blank and somehow still approved. Makes you wonder, how many cases slip through cracks like this?
One of the Jacobs. And that's problem. Well, I don't know. Maybe.
I don't know if it wasn't, maybe they let him out on that accusation on it. He said it at the 25. But it's alleged that he took a machete and was robbing a game room here, and the lady that he was robbing, she tripped and fell as she ran out the door.
This part is terrifying. The victim literally had to beg for her life, reminding him she had children. These aren't just legal charges on paper, they're stories of survival. And when a machete gets involved, judges don't see robbery, they see potential homicide narrowly avoided.
The probable cause affidavit and the defendant's prolific criminal history, which is in the public safety report, which 12 convictions, and we know that at least 4 of those are serious felony offenses, including violent crime of aggravated robbery, which is what the defendant is now charged with once again. And $25,000 is woefully too low. So the defendant's bond is $100,000. You must have a GPS device if you post your bond so that we know where you are.
Huge moment here. Bond just quadrupled, from $25K to $100K with GPS monitoring and house arrest. Translation: the court isn't leaving anything to chance. This is the justice system saying, if you walk free, we're watching every step.
and the seriousness of what you're charged with, sir, your criminal history, and the fact that this was committed in a very violent fashion, where a machete was alleged to have been displayed by you in the commission of this crime and threatening the victim. Are you working somewhere right now? How did you post $25,000 bond? Your niece. Who is your niece?
Yeah, my brother's daughter.
Your brother's son. You have been through this system so many times with crimes. You've got four.
Here, the judge flips from stern hammer to almost parental disappointment. It's like, we've been here before. You keep coming back and nothing changes. But with this record, second chances don't sound like they're on the table anymore.
Have to live in peace.
I need help. Contact.
No, talk to your, this is the lady who's been appointed to represent you. Talk to her first before you say something, because everything you say is, some people want to say something, and when they say something, it can hurt them at trial. They go, well, I did it, but I was really kidding around, or something like that. It works against them. So you don't want to speak until you talk to her first. If it's something you need to talk to me, that's fine. But the court agrees with the state that the bond is woefully low, too low under the circumstances and your incredibly rich criminal history of violence. Okay. I want to like an announcement in 4 weeks.
Yes, Judge, if we could keep him on the same docket or similar week as Crystal Row that we reset 5 weeks.
Okay. 5 weeks. Good. Thank you. Yes, ma'am.
Thank you.
We'll do that. That is all. You were in custody.